In preparation for talking to you today, I went back and read our court filings from 4 years ago, and I felt like I was going through a fever dream. Like, how is this a real period in American military history that we were going to kick out tens of thousands of well-accomplished, well-credentialed, well-trained service members for this basically ineffective mandate. It was like a nightmare reading these documents and thinking, like, we were really doing this.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at the Napa Legal Institute. You're listening to the Napa Legal Podcast, where we explore religious liberty, particularly from the perspective of faith-based nonprofit organizations. So for today's special episode, I'm joined by our guest, Nathan Loyd. Nathan is staff counsel at the Thomas More Society. He's also a lieutenant colonel in the U.S. Air Force Reserves. He has a really interesting background. He also happens to be one of our Good Counselor Project fellows this year, which makes it easier for me to rope him into a podcast episode. So, Nathan, thanks for joining us.
Frank, it's awesome to be with you again. Thank you so much for having me on.
Oh, yeah, happy to be here. So I guess before we dive into the particular line of cases I wanted to talk about, and the one particular case that just recently settled on the COVID vaccine mandates in the military, just wanted to back up and give you a chance to talk more generally. So you're at the Thomas More Society, who are friends of Napa Legal and who we appreciate very much. So can you just tell me a little bit about your work, about the organization, how you ended up there, whatever you want to say to kick us off?
Yeah, absolutely. So the Thomas More Society, it's kind of a dream job, really. I think a lot of people go to law school dreaming that nobody gets excited about big corporation contract disputes. No, they get excited about the pay, but at the heart of the work, right? It's not something that you can wake up and be thrilled about. And early in my career, I was blessed to have an opportunity to join Thomas More, and I've been litigating there for a few years now. And it's amazing to get to do what I went to law school to do. It's of course difficult, of course very exciting work, but every day I wake up and I'm excited to serve my clients, and my clients are excited to be served by me because they're not paying us. So it's easy to keep really good client relationships working in an organization like this. But the reason I went to law school, actually, I was at one of my graduation ceremonies. I got a master's degree in theology, and the graduation speaker was the plaintiff McCullen versus Coakley, and she was telling this great story about how she's this little grandma standing on the sidewalk, and the state says she couldn't be there anymore. She couldn't minister to these abortion-minded women. And her first reaction was, well, who am I to fight? I'm a nobody. I'll just do my best. And then she realized, no, I actually do need to fight. I have constitutional rights. And so she fought and, of course, got this amazing Supreme Court win. And at the time, I was active duty Air Force, and I realized I had an oath to support and defend the Constitution of the U.S. against all enemies, foreign and domestic. And of course, in the military, we take care of the foreign aspect, but the domestic, there are domestic enemies of the Constitution too. People who government actors who refuse to respect our constitutional rights. And so that was the moment I decided to go to law school. And amazingly enough, I actually got to start working with sidewalk advocates and doing that exact kind of work that inspired me to go to law school in the first place.
Yeah, it's awesome to be able to work in this kind of Christian conservative world, and to remember that, like you had said, we have dream jobs. So it's good when we meet our brothers and sisters in the legal profession who are doing big law and billing hours, to remember how blessed we are to get to the stuff we do, right?
That's right.
Yeah. So I want to cover a couple different areas, but I want to focus most of our conversation on these COVID vaccine mandate cases. So most of our listeners are familiar with the issue, I'm sure. I remember when the vaccine mandates started coming down, I guess that was 2021 into 2022. And I'm at a Catholic parish where there were a lot of people who were affected by these mandates, and I helped draft the exemption letters and did some of this stuff behind the scenes. But it was a really live issue, and particularly a religious issue for most, because especially at the time, right when the vaccine mandates rolled out, all three of the initial vaccines were tainted by aborted fetal cell lines in the research and development, which made it much more of a religious case. But I was obviously never involved in the litigation side, and you have been. And in particular, there was this recent case where made headlines, and we decided to reach out to you. It was a Coast Guard case where there was a vaccine mandate, and it just settled, I think now about 2 weeks ago, by the time this is running. So can you talk a little bit, to the extent you can, obviously, but about the facts, what was going on in this particular case?
Yeah, so in preparation for talking to you today, I went back and read our court filings from 4 years ago, and I felt like I was going through a fever dream. Like, how is this a real period in American military history that we were going to kick out tens of thousands of well-accomplished, well-credentialed, well-trained service members in for this basically ineffective mandate. It was like a nightmare reading these documents and thinking like we were really doing this. This is insane. Um, so in our case, so we had a class action for Coast Guard members against the Department of Homeland Security. It's kind of a little known fact that Coast Guard is normally under the Department of Homeland Security. It's not under the DoD at the time, DoW now, except during warfare. So our suit was against the Department of Homeland Security, class that we estimated to be about 1,300 people who had filed a religious accommodation request and were summarily denied. Public records showed us that less than 1% of people who filed a religious accommodation request were actually granted one. And the only people, that 1%, were people who already had separation orders or retirement orders. So there was not a single genuine religious accommodation request approved, which was just a terrifying statistic. So our three plaintiffs were just these phenomenal men. One was an enlisted man. Another was a lieutenant junior grades. That's the second officer rank. He was the top graduate from the Coast Guard Academy.
Wow.
Tremendous officer. He had evaluations that were saying he needs to go work at the White House, which is a recommendation that nobody gets except for him, basically. Um, and then our third plaintiff was a former Marine who became a Coastie, had a long history of deployments, had tremendous accomplishments negotiating hostage situations. And the Coast Guard threatened to kick them all out because they demanded the right to follow through with their conscience. So the mandate hit in 2021, and they started really putting the screws on people, trying to make sure that they were abiding by this. They were trying to force people into it, really, because they knew that they knew that you had to force somebody into taking this vaccine. Nobody, the final remnant who weren't vaccinated, nothing was going to persuade them. So they would do really petty, despicable things. For instance, one of our clients was training to run a marathon, and obviously he's in good condition if he can run a marathon. And the Coast Guard said that he could not go on leave just a couple hours away from his home to run the marathon because he was unvaccinated. Another one of our plaintiffs had some very important training that he was supposed to go to, and this training was essential for him to promote and make rank. And the Coast Guard said, you can't go to this training because you're unvaccinated. We were seeing all kinds of things like that, just really petty. It boiled down to petty. And at the same time, our clients were going through the process. They were doing the religious accommodation process of saying they wanted accommodation, being interrogated really by the chaplains who would ask questions like, well, have you ever taken Tylenol? Did you know that Tylenol was tested on aborted fetal cells, and these kinds of things? Really making it awkward for them instead of respecting their religious liberty and honestly helping them as a chaplain should. And then they would file their appeals because they would get denied. They get denied at the appeal stage. And when we were looking at these appeal denials, we found out that even though the appeal denial technically said that whoever had denied the appeal had reviewed it in depth and consulted with a number of people, the rate at which they were putting these out revealed that they were only looking at these for 5 to 10 minutes. It was all perfunctory. It was performative. It was nonsense. It wasn't actually designed to grant anybody an accommodation. And I just want to highlight one egregious thing. They said that one of the reasons that our clients could not get a religious accommodation was because they would have to work alongside Coast Guard auxiliarists. These are people who are basically volunteers for the Coast Guard. They don't really have any rank or pay or anything. But the Coast Guard was unwilling and unable to make those Coast Guard auxiliarists be vaccinated. And so instead of preventing those Coast Guard auxiliarists from accessing base, eating at restaurants, going into housing, going into the gym, they decided to kick our plaintiffs out of the Coast Guard altogether. So it was just an absolute insanity that led to this case getting filed.
Now, factual question. Obviously, I'm not a scientist nor am I an expert on this, but my understanding is we found out fairly early on that the COVID vaccine, again, this is not like a conspiracy theory. This is just the case, I believe. It doesn't actually prevent you from transmitting the disease, right? It does something to your immune system where like you maybe don't get the effects or don't get the effects of COVID as much, but you're still a transmitter. Isn't that right?
That's right. And so we actually had some good data published by the Coast Guard itself. In August of 2021, the Coast Guard published research showing that the effectiveness of the vaccine dropped 20 percentage points in the 3 months prior to the mandate. So they had data in their back pocket saying this was no longer effective, and yet they were still insisting on the mandate being enforced. Um, and then we also found out that so after the mandate hit in about September 2021, between a couple months later, November and December of 21, 90% of the days that people were on quarantine were for people who were vaccinated, not the
Yeah.
unvaccinated. So people were missing, the vaccinated were missing work and using the unvaccinated people to cover down for them. There was another instance, just an anecdote, one of our plaintiffs, um, he was the only person who was not sick with COVID and had to cover everybody else's shift while everybody who was vaccinated was at home. So this whole thing was justified on military readiness and military accomplishment, and we have operational duties, and we can't let these things fail. Absolutely, but objectively, what was happening was the missions were failing because the vaccine wasn't actually helping to accomplish the mission.
Yeah. So I could go on about the factual issues surrounding the vaccine's efficacy, but I'm not going to. I want to focus. So on the religious question, right? Because when everyone realizes that when you're in the military, you give up certain rights that people in the general population have. Like I know a lot of military guys, and their culture has long been like you take all these jabs. They just shoot you up with every vaccine possible because you're going across the world and you don't really have any say. But this is I mean, this was novel because it was rolled out really quickly, but also there was a legitimate religious objection. So what is the standard, right? Because you, like I said, you give up rights when you go into the military, but you obviously still have some religious freedom here. So if somebody requests a religious exemption, what is the legal standard or process supposed to be like to get that exemption request reviewed?
That's a great question. So generally, it comes down to RFRA, the Religious Freedom Restoration Act. So if the government is going to do something that is a substantial burden on your free exercise of religion, they must make sure that they can only do it if they have a compelling reason and are using the least restrictive means to reach that compelling reason. And I think that is exactly where the mandate fell apart. They were saying we need this for operational readiness. We need this to make sure we can accomplish our mission. But the facts on the ground showed that it wasn't actually even serving those missions. And then going towards the least restrictive means aspect of this, we can assume for the sake of argument that there was a compelling interest in making sure that there is military readiness. I think that's a pretty fair thing to say. But is it really the least restrictive means to force somebody to get a vaccine when they've been doing the job? For instance, one of our clients was doing his job for a full year unvaccinated with no mission effect, simply wearing a mask. And that's a much lesser restrictive means. Just, they could say, wear a mask instead of getting vaccinated. That's a reasonable accommodation. And looking back, with the benefit of hindsight, I think everybody would now agree that was probably a reasonable accommodation. Um, but at core, you have to ask, are you really serving the compelling interests of military readiness by discharging somebody who is actually ready? You go from having somebody who can contribute to the mission to having nobody to contribute to the mission. So that really undercut the compelling interest analysis as well. And then we made a First Amendment argument on the theory that the Coast Guard had granted a number of medical exemptions.
Okay.
And there was also a number of exemptions granted for people who were on the way to retirement. There was a separate accommodation process. separate from religious issues. And so our argument was, well, if you're granting these accommodations, you should also grant the religious accommodation, because the medical exemption, the retirement exemption, those are affecting your readiness in the exact same way. And the arguments that you're saying that our unvaccinated personnel are capable of spreading COVID, first of all, so were the vaccinated personnel. But second of all, that interest is equally undermined by somebody with a medical exemption or a retirement exemption. And this is, a hot topic going up to the Supreme Court right now. What exactly is the comparator? The Coast Guard's argument was, no, we are actually improving medical readiness by granting an exemption to somebody who can't get the vaccine for medical reasons, which is some interesting gymnastics. I'm not sure I really understand what that point was, but it's an argument we've seen popping up in a number of contexts. So we're hopeful that the Supreme Court can settle this and say what is actually the comparator.
Yeah, well, that's an interesting question. I suppose then the distinction would be, if you're granting an exemption for medical reasons, you can undermine readiness by not giving that, because if you don't give the medical exemption, the person's more likely to be adversely affected and not military ready if they take the vaccine. Is that the argument?
That's generally the argument, but a person who is no longer in the Coast Guard is by definition not ready to do the mission either. So I'm not sure that this makes a lot of sense.
Yeah, no, that's a great point. That this is a very live issue. There was just cert granted in a case that's going to deal with the contours of this exact question, right? Whether if certain secular exemptions are granted but religious ones are not, then that's no longer a generally applicable and neutral law, and so Smith doesn't apply, and then maybe there's a free exercise and not just a RFRA claim. I hope we'll see some added color given to that question in the next term. All right, so I guess, yeah, let's talk about the settlement. So the case was recently settled. What was the outcome of the settlement?
Our clients won. So at base, we won. And we're very grateful for that. So there were a number of lingering reputational harms that we really had to clean up. Reputational harms and also documentation of what happened. So one of the strange things that we encountered in this case was the pure duplicity of the government defendants here. So in the process of our clients being reprimanded for not being vaccinated, they were given paperwork documenting that they had disobeyed a lawful order. And this goes into their permanent records, and it has tremendous impact in their careers. So one of our clients was up for promotion to lieutenant, which is the third rank in the Coast Guard. And normally, the only reason you don't get promoted to lieutenant is that you're actually currently incarcerated. This is like an automatic promotion. And our client, who had an excellent career, was denied promotion. And the only reason was this document in his record saying he violated a lawful order. And the promotion board saw that and said, we can't let this person have any more authority. So he was passed over for promotion, which is a huge stain on his career. It's obviously losing money, just very practically. So we knew we had to clean up this documentation. And so we demanded the Coast Guard once the vaccine mandate went away with the 2023 NDAA, the military funding bill, we demanded that the Coast Guard remove these records from their files. And the Coast Guard represented to the district court, we've done this. But in reality, when they removed that record saying you violated a lawful order, what they didn't say was put another document in the record saying, we've removed another record saying you violated a lawful order. So technically, they had removed the one saying they violated a lawful order, but they still had this scarlet letter in their records, flagging for the same thing. And the district judge, unfortunately, bought that line of argument. He said, well, this doesn't really matter so much because it's been replaced, and they have to keep this anyway because it's federal record-keeping requirements. On appeal, while our appeal was pending, we found out they actually do change records all the time. One of our clients had his own records changed, documenting that his promotion date had changed. So with no backstop record documenting the change, right? So that's not a legitimate objection. And then we found out that they were keeping secret copies of these letters saying that they had violated a lawful order. They had kept secret paper records that our clients didn't even know about that commanders could still see. And then we found out that they were copying those paper records back into the digital file so everybody could still see it. So this came up on appeal, and the duplicity of the Coast Guard in this whole thing was just just insane, like basically lying to the court. So we had to clean up that. So we got in the settlement, those documents are gone, which we're very grateful for. We also have a number of formal pronouncements from both Coast Guard and DHS saying that the vaccine mandate was unlawful. And that was very important to us. So one of the things that saved the case, we were initially dismissed as moot because the Coast Guard kept, they would look at what we asked for, they would do it on their own, and then say that the case is moot, trying to prevent us from getting a final judgment. And one of the lingering issues that we saw was this issue of reputational harm. So one of our clients had a connection to a retired vice admiral. This man was a rock star in the Coast Guard. He commanded Coast Guard units from the Rocky Mountains to the Eastern Seaboard, 100 ships, over half of the operational force of the Coast Guard and over half of the aircraft of the Coast Guard were under him. And he, thank God, was willing to, he had the courage to stand up, even though it was very politically unpopular, and file a declaration in our support saying, yes, even if the documents are gone. Coast Guard leadership, it's a small service, everybody knows everybody, and they're still going to talk. In the background of the promotion boards, when somebody's getting a new assignment, that commander is going to call somebody, they're going to have a conversation and say, I know that you don't see a record for this, I know this guy was bad, don't promote him, don't give him a job. So he filed a declaration, which was instrumental in the Fifth Circuit holding that the case was not moot, that we needed to remedy this. So part of that remedy in the settlement was to have those formal pronouncements that the mandate was unlawful, to stick it in the mind of all of the senior leadership, what you did was wrong, and you cannot hold it against these men anymore. So that was another huge one. We're also very grateful we got some good attorney fees out of this settlement, which helps fund Thomas Moore's next line of cases. We got the Coast Guard to update a regulation that inappropriately said that there was not a requirement to do a to-the-person analysis of religious accommodation and what their situation was. And we also have the Coast Guard now giving a religious liberty training that Thomas Moore is helping to develop for the Coast Guard. So it's a tremendous settlement, it's monumental, and it really sets the foundation for anything in the future. The next person down the line who has a vaccine exemption or any kind of religious issue in the military can look to this settlement and say, this is what Thomas Moore got, this is what these plaintiffs got, give me the same thing. So we think it's a great precedent for the future.
Excellent. Now, I'll talk a little bit more about the precedent and the future of these cases in a minute, but you had said something, we talked about this offline. You had mentioned this voluntary cessation doctrine, basically this process where, I think it's what you were just saying, where plaintiff files a lawsuit and then defendants take actions to remedy some of these things on their own and moot the case. So why can this be a problem? Like, how is this an issue? Because aren't you're getting what you want, right? They're fixing things on their own. So why is this a problem?
So it's a huge problem for pro bono civil rights groups. And the reason is, just last year, the Supreme Court said in a case Lackey versus Stinney that getting a preliminary injunction is not enough to render you a prevailing party under 1988 to get attorney's fees for a civil rights case. And so there's every incentive now for a government defendant to say, oh, it looks like we're going to lose this case. Let's save some money. We'll do everything they're asking already and tell the court the case is moot. That way we can avoid paying some attorney fees. It's a really, really nefarious tactic. And in this case, in the Lackey versus Stinney case, the Supreme Court specifically said, look, we understand this is a concern, but don't worry, voluntary cessation doctrine is there to save you. Voluntary cessation doctrine is this doctrine that if a defendant voluntarily moots a case or ceases their actions that are being challenged, they need to prove that they're not going to resume after the case is over, because obviously there's a perverse incentive. Right. You don't want an adverse judgment against you. And there was another case last year, FBI versus Ficre, which confirmed that voluntary cessation doctrine applies to government defendants. It's not, they don't get a presumption of good faith. They don't get any kind of, they can't make a pinky swear that we're not going to resume. They actually need to prove that they're not going to do the challenge actions again. It all sounds good, right? But Thomas More Society did a study last year about this and looked at appellate cases involving voluntary cessation since FICRE came out. And we found that there were 56 appellate court decisions that discuss voluntary cessation. 48 of those were against government defendants. So government defendants are the one most likely to use voluntary cessation to try to escape a case. I think that there's this presumption that it's the government. They're going to act in good faith. They're good people and they're serving the people, so they're not going to play games like this. They absolutely do, and they have even more an incentive, obviously, to do this than a private defendant, because a government defendant is going to be a repeat defendant. Walmart, for instance, might get sued, and they may moot out a single case, but that's not going to be a precedent that's used against them in the future. Government defendants can be bound in eternity, basically, by an adverse judgment. So we were just shocked to find out that so many cases actually involved government defendants. And going a little deeper, we discovered that in 34 of those cases, the appellate courts found that the government was entitled to a presumption of good faith and did moot the case, even after the Supreme Court's decision in FBI versus FICRE. So the appellate courts are not following this precedent. They're still granting this presumption of good faith to government defendants. And that's what we were really worried about throughout this whole thing. We noticed that we would make a demand, maybe even in a negotiation, and then see that the Coast Guard would do that same thing right afterwards, outside of the purview of the court. And they were also doing this. There's this other very pernicious tactic they used at the beginning of the case, where the district judge said, "I'm not willing to grant you a TRO just yet, because I think you guys can come to terms on how to delay somebody getting discharged for the COVID vaccine, one of your class members, for instance." And so Coast Guard heard this and said, if we just make sure to stay outside of the TRO bounds, we won't actually get an adverse ruling against us. So whenever one of our class member clients would come to us and say, "I just got a notice I'm getting kicked out tomorrow," we would tell the Coast Guard and they would say, "Okay, we'll delay for 2 weeks. We'll delay for 2 weeks." They did this a dozen times, always keeping themselves outside of the bounds of where a TRO could be invoked, to avoid that adverse ruling. So this is, I think, an issue that every single civil liberties group, left and right, is seeing, where government defendants know this tactic and are exploiting it. And I really hope that somehow the Supreme Court resolves this issue, because there is a perverse incentive here, and the courts are helping that perverse incentive to stay alive.
Wow. That's helpful background that if you're not litigating in this area, you would never really think about. Thanks for that. So before we talk about the longer term ramifications for these cases, I want to just ask, to the extent you know or can shed some light on this. So you said about 1,300 Coast Guard members were involved in this class action. What were they doing after, and what are they doing now? Like, after getting the settlement, are people going back into the Coast Guard? Are they just moving on? Like, what is the breakdown of how people respond even after this stuff is remedied?
Yeah, it's a wide variety. So the Coast Guard and all the military branches, in fact, have opened up pathways for people to rejoin the military, with back pay, which is tremendous. And I'm grateful for the new administration opening that up, because that is an important pipeline. There's a lot of harm. But a lot of people, they were kicked out and then had to find another career. And at this point, I don't blame them for feeling a little bit burnt by the process and wanting nothing to do with the military ever again. And in fact, that's why we were seeing this huge retention and recruiting crisis over the past couple of years, which thankfully is resolved. But who would want to be in a military that's going to tell you, go suffer, go away, we don't want you, your services are no longer needed? And unfortunately, too, a lot of it, the worst stories I've heard were of young enlisted people who, and generally, for your listeners who may not be familiar with the military, generally an enlisted person is somebody who joins right out of high school, and does more technical things. They're the ones turning wrenches. They're the ones loading bombs. They're the ones with skill sets that are really just applicable to the military. Officers, on the other hand, go to college first and then join. So they might have some other skill set that has a civilian equivalent. So when an officer gets separated, the officer can generally find find some other career, find some kind of employment. But the enlisted guys, there's no civilian job where you go to load bombs on airplanes.
Right.
And so these people were the ones getting kicked onto the street. I heard this one story about this young man who was in Alaska and was given 72 hours to vacate his on-base house and had to drive from Alaska to Arizona in his beat-up 1994 Civic because the Coast Guard said you can't live here anymore, and if you come back on base, we will arrest you. And so, unfortunately, they were targeting these people. And for those people, the path forward for them is they can file a request to the BCMR, the Board of Correction and Military Records, and make sure everything is cleaned up. They can try to get back pay. They can try to rejoin if they want to, of course. And so those options are available to them, and we're very grateful that those options have opened up. But also, I can't blame them if they say, I was so burnt by this, I'm not going to come back.
Yeah. Yeah. It's unfortunate. Like you said at the beginning, you're not losing the dregs. You're losing some really admirable and standout people were burned by this.
That's right. And I think it's important to note that men like our clients are the officers that you want in the military. They're the ones who are willing to say that's an unlawful order. If you don't
Mhm.
have officers who are willing to say that and stand on their grounds and take a personal risk, that's how you get my lie. And in fact,
Yeah.
there's this great story of this warrant officer, Hugh Thompson, who, he's junior ranking to a lot of people because he's a warrant officer, but he was there during the My Lai massacre, and he actually turned his helicopter around to point his guns at the Americans who were murdering civilians. And he was court-martialed at the time, but now he has tons of accolades, and he's the model of what good leadership looks like to know when there's an unlawful order. And yet we were preferentially kicking out the people who were willing to stand, to have a moral compass, to say this is wrong. We have rights that need to be respected. So it really was a purge of some really top talent. Thankfully, it's over now.
Yeah. So moving forward, I guess I have a question. I think a lot of this is just process, but I mean, COVID was early 2020. The vaccine mandates rolled out 2021, 22. So we're talking like 5 years ago. Why are these still live issues? Like, why are there vaccine mandate cases being litigated now? Like, how is this not over?
It's insane, isn't it? We
Yeah.
we thought that this would all end years ago, but we just got our settlement now. And I don't want to get too much into our settlement negotiation process, but what we observed is that there are certain key players throughout government who are still being stumbling blocks. They don't want to admit that what happened 4 years ago was ever wrong, and they have ways to slow roll, they have ways to obstruct, and they have ways to delay and just prevent us from getting settlements and moving on. That's why these cases are still open, unfortunately. We need, I think the lesson here that I've learned is we need good men and women with conservative backgrounds who are willing to serve in government. And it's difficult, right? I live in Atlanta, and I have a lot of kids, and I can't afford to move them all up to DC for a couple year assignment. But I encourage anybody who is conservative and can do that, please go to DC, do your time in the government, help help set things right before it turns again.
Yeah. Yeah, we have a lot of friends, thankfully, in the Good Counselor Project Fellowship and in the Napa Legal orbit more generally, good, solid Christians who are working in the administration. And yes, it's hard work, and I wouldn't want to in any way demean the military life, but it feels kind of like a deployment for a lot of
Yeah.
them. Like they're not from DC, they don't want to live there, but they go and they take a pay cut and live in the capital and do this as a public service. It's really important work. Um, I guess I don't know how many more of these cases are out there. I know that Thomas More is working on other ones, some of which you can't comment on, but just as a general trend, what impact do you think that this settlement will have on future cases, and what does the trajectory look like for the remaining vaccine exemption cases? Like, are things looking up? What's going on now?
Yes, I think things are looking up, at least for the cases against the federal government. There's a lot of vaccine cases that are still pending against state governments and local governments and employers too. And those are still being fought and I think a large part of it is we're so far into this that the attorney fee bill is going to be huge. And so the defendants feel like they are stuck between facing a huge attorney fee bill and potentially settling and finally ending this. I can't really get into the psychology of somebody who's actively defending these choices 5 years after the fact. I think all of society has realized this was probably an error. This period in history was we made some mistakes and we need to fix it. So I don't really understand, besides hubris and pride, why somebody would continue defending this. Um, but I think, back in 2008 or so, there was another lawsuit against the Coast Guard for the anthrax vaccine mandate. And it resolved in favor of the plaintiff, which is fantastic. But unfortunately, it just gave relief to that plaintiff. That individual plaintiff was the only person who didn't have to get the mandate. And had that resolved back in 2008, maybe to a final judgment, maybe to a good precedent, things would have been different for us and our clients in 2021. So we had that in the back of our mind when we were settling this case. How do we make lasting change? And the way that we made that lasting change is to have this very public, very important settlement with a declaration that what happened was unlawful coming straight from the top. So it was, Secretary Mayorkas had to say it. He didn't. Secretary Noem had to say it. She didn't get around to it. And so Secretary Mullin is the one who's going to be saying this was unlawful.
Mm.
Secretary Hegseth has done the same thing. So I think that there is a really great foundation that vaccine mandates can be unlawful if not properly. They're not unlawful per se, of course. There are reasons to have a vaccine mandate, but you have to respect religious liberty in the process. I think another encouraging thing that happened recently was Secretary Hegseth just said that the flu vaccine is no longer required for Department of War military members. And so I think there's this general inertia to let people make their own health decisions, which is just fantastic.
Yeah. Excellent. Yeah, that's it's an important thing. Like you said, I think the actual declarations that these are unlawful orders coming from the very top, that's heartening and kind of surprising to see. So great outcome. Now, before we close, I just wanted to mention some of the other stuff you're working on. I know we had talked off recording about the abortion pill reversal case. We had Daniel White on a few weeks ago, and she talked about their case in California on this issue. But also, I think in particular, I think the sidewalk counselor cases, the pro-life workers, it's something that I know you work on a lot, and it's of interest to a lot of our listeners. So can you tell us just a little bit about, yeah, what you're working on and the importance of particularly the sidewalk counselor work?
Yeah, after Dobbs, we saw a huge uptick in uh, cities and states passing restrictions on access to the sidewalk outside of abortion clinics. And I think that basically every accusation is a confession when it comes to these situations. By saying that we can't have the pro-lifers on the sidewalk, they're admitting that the pro-lifers are very effective and that their constituent, the Planned Parenthood or whatever clinic is in the area, is losing money because of the effectiveness of the pro-life outreach on the sidewalk. So what we see frequently across the country is these ordinances that are, it's almost conspiratorial. We'll see the same ordinance pop up across the country in different localities, and we knock it down, and then they manipulate something and try to do it again. Recently, we settled a case in Minneapolis. The city council had passed a law at the request of the former head of NARAL Midwest, I think, who was a city council member who was best friends with the head of the Planned Parenthood down the street. At his request, they passed this ordinance prohibiting pro-lifers from walking across the driveway. The driveway is still sidewalk. The driveway apron at least is still sidewalk, and so they're allowed to be there. And we sued and were able to knock that down. But I'm in constant contact with some of our clients who are sidewalk advocates who report harassment from police. Police officers will just park outside of where they're working and just intimidate them, just stare at them, just try to scare them away. Police are often called out to the sidewalk because the security person at the abortion facility, just wants to harass them. And the police respond, and then they come and say, "Look, we understand what you're doing here. It's fine. Just we had to come out." So it's a constant battle. It's whack-a-mole, and I'm not sure that battle will ever end, unfortunately, because there's always going to be somebody who wants to use the police to harass. And so whenever this happens, we send letters, we engage with the police, we let them know, look, we're not there to firebomb. We're not doing anything wrong. We're just doing First Amendment activity. And thank God for the First Amendment, which lets us be out there. Another case that we're working on right now, which is a very interesting case out of Massachusetts. There is an abortion facility adjacent to a pro-life facility. The pro-life facility was so effective at marketing that a lot of women were going there instead of the abortion facility, and the abortion facility started losing money. So they concocted this whole conspiracy theory about how the little grandmas who work at the pro-life clinic had actually somehow used super advanced hacking abilities to go into the appointment line run by the national medical organization that serves the appointment line for the abortion clinic and stole client information, was reaching out to them and harassing them. It was insane. Of course, it was wrong. But then they've changed their theory here to be an unfair competition theory, saying that the pro-life clinic is unfairly competing with the abortion clinic by running ads to women telling them that they can have free ultrasounds. It's absolutely insane. The First Amendment clearly protects what's happening here because they're just telling women we offer free services. More to the point, there's not even a competition.
Yeah.
Our client is the advertising agency who helps place these ads. They sell ads. They don't sell abortions. So I don't see how they're possibly in commercial conflict with the abortion facility.
Yeah.
But unfortunately, we just lost our motion to dismiss, so we're working on how to resolve this right now. But we think this is going to be a very hot topic about what exactly is commercial speech. We argue this is protected speech because there's no commercial transaction, right?
Right.
Right. So how can it be commercial speech? We're not advertising for any money from to get any money from the women that are being targeted with ads. But unfortunately, there's bad precedent at the Ninth Circuit on this topic, saying that simply by telling donors that you are doing your pro-life services for free means that the donors are going to give you more money, and so therefore you have an economic motive. And so, since there's an economic motive, this is actually commercial speech, which has lower protection under the First Amendment. Which, unfortunately, that's the live precedent in the Ninth Circuit. Our judge followed that precedent and thought that was a good idea out of the First Circuit. So, we're hoping to get that remedied.
Yeah, unfortunately, we have a long history in the last century of our courts interpreting a lot of things as commerce that are not, in fact, commerce. I mean, right?
That's
was
right.
that Wickard v. Filburn, right? Even if you're growing your own grain on your own farm, you're affecting commerce because it lowers the prices. And
That's right.
the things that are not commerce can be commerce, apparently.
And you're feeding it to your own chickens on your own farm.
That's right.
I saw a funny post. Somebody was like, I can't believe like Grok is so bad at hallucinating cases. It just made up this case about you can't feed your own wheat to your own chickens on your own farm. I can't believe it.
Yeah. Great. Well, I think we can wrap there. But I mean, from these vaccine mandate religious exemption cases to the sidewalk counselors, you're really doing great work, you and all the lawyers at Thomas More. So we're so grateful for the work you're doing and for having you. So thanks for joining me today.
Thank you so much, Frank. It's always great to talk to you.
Yeah, thanks, Nathan. And thank you to our listeners for joining us for another episode of the Napa Legal Podcast. As always, if you enjoy the content we're putting out, we appreciate if you like and subscribe on YouTube or Spotify or wherever you happen to be joining us from. And we hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious freedom and particularly the work of faith-based nonprofit organizations. We'll talk to you soon. Thanks for joining us, and God bless you all.